if the election challenges had gone Trump's way and they hadn't met and voted on that day,
they couldn't count them.
You can be certain that the Democrats would be saying those votes can't be counted.
Right.
Mainstream media gives you the impression that there is nothing good about America. In direct contrast to that, my podcasts will prove by examples that America has always been and still is the land of opportunity for everyone.
Welcome to another episode in the series Life Lessons with Dr. Bob. My guest today is John Eastman, a lawyer who has been in the news, on the wrong side of the news, for the past few years because of the advice that he provided to President Trump regarding challenging the outcome of the 2020 election. Before we get into our conversation, in which we'll explore details about his advice and the intense fallout that resulted, I want to tell you first about his background. Dr. John Eastman is one of the preeminent constitutional scholars, educators, and attorneys in our country. And here is the path that got him there. He earned a BA in both politics and economics from the University of Dallas, a law degree from the University of Chicago Law School, and a PhD in government from Claremont Graduate School. That degree has given him the right to be addressed as Dr. Eastman. But in our earlier conversations, he told me that he's comfortable with just John. So that's what I'll use. Following law school, John practiced law for a variety of clients and in different venues. He clerked at the United States Court of Appeals for the Fourth Circuit, and then for Clarence Thomas at the United States Supreme Court. And he represented the states of Arizona, South Dakota, and North Carolina in various cases. John also practiced law at the prestigious law firm of Kirkland and Ellis, where he focused on civil and constitutional litigation. In addition to practicing his trade, John is also a prolific writer. His scholarly publications include books and articles, most of which focus on the American Constitution. And John's commentaries on our legal system have been published in the national media as well, including in the New York Times, Washington Post, Wall Street Journal, U.S. News and World Report, LA Times, and The Economist. And his commentary is not limited to print. He's also appeared on C-SPAN, 60 Minutes, and on Fox. Now, John gained national attention in December of 2020 when he was retained by President Trump to advise his legal team in its efforts to challenge the results of the 2020 election. John brainstormed on that issue and wrote a number of memos exploring different scenarios on how the results could be legally challenged. We'll get into more details on that in our conversation. But as we all know, Vice President Pence rejected John's legal arguments, and on January 7th, 2021, Pence certified the count of the electors and officially declared Joe Biden as the winner of the election. But because of John's lawful efforts on behalf of his client, he has become one of the most targeted individuals in the left's use of lawfare to silence political opponents. John was investigated by the U.S. Department of Justice and was later indicted under various criminal statutes in Georgia and Arizona. Both of those cases are ongoing. In addition, he is currently facing disbarment, the removal of his right to practice law in California. That is one hell of a story, and it's not over yet. John, welcome to the show.
Dr. Bob, it's a real pleasure to be here. Thanks for having me.
My pleasure. But before we start, I'm aware that you're still involved in litigation, so it's completely understandable if you can't answer some of my questions fully. But let's start at the beginning. When was your first contact with the White House, and what did they request of you?
Well, even before the election, President Trump saw me on the Mark Levin show talking about the illegality of the Mueller investigation. And he called and said, I'd like you to come to the White House and meet with me. And I thought there would be some agenda item. He just wanted to get to know who I was. Mm-hmm. That was also the first time I met Rudy Giuliani, because about an hour into our meeting, the secretary knocked on the door and said, Mr. President, your next meeting's here. Who is it? Well, it's Rudy Giuliani. Tell him I'm in a meeting. No, tell him to get in here. He needs to meet this guy as well. Mm-hmm. That was August of 2019. And then, of course, a year later, after the election in 2020, the cases were being thrown out left and right without ever reaching the merits of the legal claims or the actual evidence of illegality that it was being presented to the courts. And he contacted me late November, early December to say, can you help us design a strategy that has a chance of getting the Supreme Court to actually do their job and look at the illegality that's going on? Mm-hmm, and I mean, the President of the United States calls you to ask you to do a Supreme Court case for him. That's a no-brainer. Even in hindsight, after I've suffered the lawfare that we've been dealing with, I would do it again, because what I saw in that election was a lot of illegality, and it just wasn't getting addressed.
Mm-hmm. Mm-hmm. So who retained you? Was it President's legal team or the President himself? Who was your client?
The President himself. The President called me directly and asked me to represent him. And also to represent the campaign. So mm-hmm. I was representing both of them.
And what was expected of your services?
Well, the first thing out of the box was Texas filing a lawsuit against 4 of the swing states for them violating their own rules on how to conduct the election. And they filed that as an original action in the Supreme Court of the United States, because our Constitution allows disputes between states to go directly to the Supreme Court. Oh. And then I filed a motion to intervene on behalf of President Trump in that action. So that was first week of December. So that was the first thing right out of the box.
But the basic desire of the president was to investigate the possibility of invalidating the election.
Well, it was, but very important to focus on that word investigate, because he made clear in a number of statements, and also to me repeatedly, that we're not looking to just have somebody substitute in my electors for the other electors. Mm-hmm. We want an investigation so that the choice that was actually made by the American people, no matter how the chips fell on that investigation, mm-hmm. but that choice was respected. And what we had was state legislators that said our rules were ignored. They were unilaterally suspended or violated by county clerks, by secretaries of state, by state trial court judges. Even though the Constitution is very clear, the state legislatures had the sole power to set the rules for how we're going to choose presidential electors. And when those rules were violated, the state legislators were advising Congress that our rules were violated, this election should not have been certified. But nobody's looking at the impact of that illegality. That's critically important, because if the impact is greater than the margin for Biden and Trump actually won, consent of the governed requires that we certify Trump. But Trump never said, certify me no matter what.
Yes.
It was always investigate. I'm confident that if the investigation is done honestly, I will win. But wherever the chips fall, that's what the Constitution requires.
Right. Now, I understand that you took Trump's request very seriously, and that you spent hours brainstorming on various legal methods to challenge the counting of the electors' votes. So how many different scenarios did you come up with?
Well, so before we get to the scenarios,
sure.
we had the Texas versus Pennsylvania case. We filed a major brief in that. And then after the Supreme Court declined to take that case, there were still cases pending in Pennsylvania, Wisconsin, Georgia, and Arizona. And I was involved in Georgia, in Pennsylvania, and in Wisconsin, bringing those cases to the Supreme Court. And unfortunately, they just sat on them. And then some months later, they just dismissed them all because they become moot. Too late. So since the courts were not taking seriously their role in assessing and deciding these controversies, we came up with alternate strategy. Okay, well, the Constitution says when you get to the joint session of Congress, the House and Senate are merely to be present. The Vice President's role is to open all the certificates, and then they shall be counted. Open them in the presence of the Senate and the House, it says. And they're just to be present. They're just to observe. And if there's decision-making that needs to be made, my assessment was that it was the vice president's role.
I see.
So the brainstorming memo I did looked at 9 different scenarios. Well, what would happen if if Pence just accepts the Biden electors? Well, then Biden wins. If he does Y, well, then Biden wins. 9 scenarios, 5 of them had Biden winning. And in fact, the last of the scenarios had 2 different paths, and that was the one accept the requests from hundreds of state legislators who are advising you that their election was illegally conducted for a little bit of time to assess the impact of that illegality. Why did they need time in January? Why didn't they do that in December or November? Because their governors refused to call them into special session. Now that first week of January, they're coming back into normal session, and they're meeting, and they can do something about it. And they can assess the impact. And then that scenario says, and if the impact is smaller than Biden's margin, Biden wins. Significantly, Biden wins. And we then have 2 things. One, we have confidence that we've certified the right guy. And the Trump supporters will have some solace to know that it actually got looked at instead of being punted like the courts were doing. And that would have healed, in my view, this scab, this festering wound on our body politic. Not for everybody. There still would have been some people that didn't accept it even after that. But the frustration that most people had was we saw this with our own eyes. We saw illegality. Nobody ever looked at how much that illegality affected the outcome. And we think we deserve that because we're the sovereign people. We give our consent of government by fair elections, and it wasn't fair. And we want to know whether it affected the outcome or not. And you courts never told us that. You never gave us an opportunity to have that heard. So that was that scenario. But if, in fact, their investigation showed that the illegality affected more votes than the Biden margin, and we can ascertain that if you only count legal votes and don't count illegal votes, that Trump actually won, then that scenario said, and then Trump should win, right? Because that's what consent of the governed requires. That was the advice. That was the brainstorming memo that, Liz Cheney and others in the J6 committee thought they'd found the smoking gun, as if I'd made all this stuff up. But that was how.
And the legislatures of how many states raised their hand and said, wait a minute, there was something illegal happening here. We have to investigate this.
Seven different states.
7 different states. And when I say the legislature, did they have to vote on it, or just one senator, one congressman, or whatever in the state?
So we had people say, well, these legislatures were all Republican and they weren't actually taking action. And I would tell people, you got to distinguish between Republicans who supported Trump and Republicans that were violently anti-Trump. And when you take the anti-Trump Republicans and add them to the Democrats, most of those legislatures were Democrat.
Oh, they were.
Yeah,
I see.
All right. But the Republican, call them the Rhino Republicans or the anti-Trump Republicans, their constituents were demanding that they look at this, and so they were saying, well, we don't have any authority to look at it. And so my strategy was to call them on that bluff. They didn't want Trump to be elected, but they were telling their constituents, I wish I could do something about this, but I really can't. So giving it back to them would have called their bluff and would have said, you guys look at this and do an honest assessment of the impact of the illegality. And if you come back and can honestly tell us, even taking account of that illegality, Biden won, then we'll certify Biden. And the American people, by and large, will accept that result in the way they weren't willing to accept it when everybody kept shuffling this under the rug.
So that's the advice, and you sat down with President Trump, I assume, and described this is what we have to do. So
in a meeting in the Oval Office on January 4th, was President Trump sitting behind the Resolute desk, and to his right or my left was Vice President Pence, and then I was sitting across from President Trump from the Resolute desk, and then Mike Pence's chief of staff and general counsel were also there.
And Rudy? Was Rudy there?
No, Rudy was not there. It was just the 5 of us. And the president said, now, is there any authority for Pence just to substitute in Trump electors for for Biden electors. And Pence turned in his chair to me and said, "Do you think I have that authority?" And I said, "Mr. Vice President, it's a close question. It's an open question. It's never been resolved. But quite frankly, under the circumstances here, even if you had that authority, I think it would be foolish to exercise it."
Without having that investigation done.
Without the investigation, without the legislatures or anybody else having certified the alternate electors. At the moment, they were just there as electors had sent. They weren't certified because no investigation had been done. And I said, but that's why we're recommending that you accept these requests from hundreds of legislators.
Wow.
Hundreds of legislators, including one that came in that night, probably the most important letter. One of the anti-Trump legislative leaders was in Pennsylvania. Senator Toomey was not a big fan of Trump. He was Republican, and his protege was the leader of the Pennsylvania Senate. On the evening of January 4th, he sent a letter purporting to represent a majority of the Senate, of the state Senate in Pennsylvania, saying our election was illegally conducted and should not have been certified. Please give us a little bit of time so that we can make sure due process is followed.
Wow.
That was the most significant of the letters that came in. But there were others, that Arizona, Georgia, Wisconsin, Nevada, Michigan, all seven of the swing states.
So who in each state certifies the electors?
Well, it depends on state law.
I see.
In most states, it's the governor after the Secretary of State reports, and then the governor certifies.
I see.
But so here's another interesting part of this. Think back 40 years, 1960, Kennedy versus Richard Nixon.
Yeah. The hanging chads?
No, that was 2000. We'll get to hanging chads in a minute. That's another interesting story.
Oh, this is Chicago.
1960, Chicago and Texas and Hawaii were all disputed. Richard Nixon realized there's no judge in either Texas or Chicago that's going to rule my way, so he left those alone. But in Hawaii, Nixon won the election on Election Day, and the governor certified him as the winner. But there was an election challenge pending in court when the day that electors needed to meet, just like there were election challenges pending in each of the 7 swing states when the electors needed to meet on Electors Day in December. Back up one step, the state legislators have plenary authority to decide the rules for choosing electors. They could choose them themselves if they want. In fact, for the first third of our nation's history, most of them did.
I see.
Which makes our state legislative elections every 4 years really interesting. Yeah. But all of the states now have popular election, but the manner for choosing those electors is in the state election code. Right? And they were violated. The one authority that Congress has, the only authority, and by the way, our founders were quite explicit about this, they did not want Congress having any power over the selection of the president, because then that would make the president subservient to Congress, and it would destroy separation of powers. The only power Congress has is to set the date for the electors to meet and vote. And the Constitution requires that that date be the same throughout the country. They didn't want anybody seeing what happened in New York. And then kind of mucking around, right? 1856, and I know you weren't there, Dr. Bob. I think maybe Rudy was, but other than that, 1856, there was a blizzard in Wisconsin, and the electors couldn't meet and vote on the designated day. And they met the next day. And when it gets to the joint session of Congress, 2 very important things happen from my advice. One, the acting president of the Senate, there wasn't a vice president at the moment, the seat was vacant, but the acting president of the Senate decided to count those votes from Wisconsin. There were objections made from the floor, and he ruled them out of order. Why? Because the Constitution says the House and Senate are just there to be present. They're not there as a legislative body. They're just to observe. He ruled them out of order and then gavelled the session closed, and James Buchanan was declared elected president. Now, he was going to win with or without Wisconsin votes, but the vote tally that he reported had the Wisconsin votes included in it. So he made the decision to resolve that dispute, and he also made the decision that he was the only one that could resolve that dispute.
Right. So we have history saying that the president of the Senate can make those decisions.
Yeah. And then it gets back to the House and the Senate after the session is convened closed, And they debate whether that was constitutional or not for the next several days, and they don't resolve it. They table the motions. There it's been since 1856, unresolved. So you get to
But in that case, it wouldn't have mattered.
It wouldn't have mattered.
Okay.
But and people saying we need to resolve this now because at some point we're going to have a case where it does matter, right? Fast forward to 2020, it did matter. It would have been nice if we had a ruling on this, but we don't. It's still an open question. In Hawaii, in 1960, John Kennedy's suit challenging the election results in Hawaii was still pending on the day those electors had to meet. So the Nixon electors meet, and they cast their votes, and they're the certified electors. The governor has certified Nixon the winner. The Kennedy electors meet without any certification, and they cast their votes, and they signed papers that said, we are the certified electors of Hawaii, even though they weren't. And they send those papers to Washington, D.C. And then 2 weeks later, the court action ends up ruling that Kennedy had actually won. So the governor certifies a third slate. Now the Kennedy electors again signs it, and now they're certified, and they rush that because that's the morning they rush it. It arrives in Washington, D.C. the morning of the joint session of Congress. Nixon opens all three, said, I got three here. What am I supposed to do? Without setting a precedent, I think I'm going to count the subsequent certified Kennedy electors. But when he said he had three, that meant he's looking at the Nixon certification, he's looking at the uncertified Kennedy electors, and then he's looking at the Kennedy certified electors.
Yes.
And he decides to count the Kennedy certified electors. Now, he says, without objection, and I don't want to set a precedent, and there's a dispute whether Congress could have overridden his decision or not. Again, same issue we had before, it's not been resolved. But that's why the Trump electors needed to meet on December 14th because there was still pending election challenges. And it's the fact that those electors met and sent in certificates that said we are the duly certified electors from Georgia or Arizona, that these criminal charges are brought against those electors and the lawyers who said it's important for you all to meet and cast your votes on that day. Because if the election challenges had gone Trump's way, and they hadn't met and voted on that day,
They couldn't count them.
you can be certain that the Democrats would be saying those votes can't be counted.
Right. I see.
Yeah.
I see. Okay, so you met in the Oval Office.
We met in the Oval Office.
And you made your best case.
Yep. And Vice President Pence has been on the hustings saying he made clear during that meeting he had no authority to do that. That's a lie.
Right.
That's a lie. Right. And, anybody that knows a little bit about Mike Pence's character, you just have to ask this question. Do you really think he was going to have that conversation in person with President Trump? Right? No, he kept saying things like, that's a very interesting thing. I'd like John to meet more with my staff tomorrow or tonight later to talk about, because we had recommended just delay a little bit so that the state legislators could look at the impact.
So legally, he could have delayed. That was his decision to be made.
That was my assessment. That was my assessment, because he had the ultimate authority to resolve. And by the way, we've got a historical example of long delay, too. In 1876, the Rutherford Hayes and Tilden election, there were dual slates of electors from half a dozen states. And if all of them went toward Hayes, Hayes wins the election. If even one of them goes toward Tilden, Tilden wins the election. And they didn't know what to do about this. And it was Reconstruction, and there was massive fraud in the South, with the Democrats trying to block black citizens from voting and all this stuff, threats and all this stuff. And so Congress sets up a commission that spends months looking at all this. We had more time then because inauguration wasn't until March then. And they took almost all the way up till inauguration to decide that, and they took a vote on every one of the electoral votes, and they decided all of them went to Hayes, and Hayes won. And the Democrats were furious. The deal that was cut to prevent a renewal of the Civil War was essentially Republicans pull out the military from the South, Reconstruction ends, and then unfortunately opened the door for Jim Crow for a century. But
getting us back to this issue. So you had the meeting. It went on, I don't know, let's say an hour or something.
Yeah.
And you just leave.
I leave. Vice President says that's a very interesting question about delays, to send it back to the legislature. I'd like my...
Nobody asked him, are you going to delay?
No.
If I were Trump, I would turn to him and say, Mike, it's really your call, but I want to know, are you going to delay?
Yeah, and Trump basically did just that, and he said, I need to assess this more. I'm going to have John meet more with my staff. He did not want to take a position here. Now, we subsequently find out that they'd already decided several weeks earlier that they weren't going to do anything, even though he's out giving speeches intimating that he's going to do something, right? Even that night and the next day, he's still giving speeches saying, I will make sure we do something about this. That they'd already decided weeks earlier.
So what happened to you next?
So
you just go back to Santa Fe and the regular practice of law, or writing books, articles?
And I was at the time a visiting professor at the University of Colorado, and when the riot at the Capitol occurred on January 6th, the University of Colorado canceled all my classes.
Just your classes?
My classes. The night before the classes were due to start, and they said you could do independent study if you want, but they prohibited me from accessing the student emails for even the students that had registered for my classes to contact them to say if you want to sign up for independent study. And then they barred me from coming on campus, and they barred me from using my title when I was out speaking.
Now, by that time, was there media about the issue? There was a lot of media.
Because I spoke at the Ellipse right in front of the White House on January 6th. I was the last person to speak before President Trump. Now, that was completely unplanned. President Trump that morning was still on the phone with Mike Pence, trying to convince him that he needed to do something to address the illegality.
Yes.
And that meant he was supposed to come speak, and he was going to be delayed an hour. And, it was cold January.
Who was supposed to come speak?
Trump was supposed to speak at that big Stop the Steal, Save America rally on the Ellipse. And there were probably 500,000 people there. And they were singing and listening to Lee Greenwood, and it was a festive crowd. Although they were mad about what they had seen happen in the election, and they wanted something to be done about it. But you can only replay Lee Greenwood so many times in a row, and hour-long or hour-and-a-half long break in the agenda. So the event organizers call over to the Willard Hotel, where Rudy and I and several others had what we called a war room, trying to track what was going on with the litigation, what legislators were objecting, all that stuff. And they said, Rudy, can you come over and say a few words just to fill some of that time until President Trump can get here? And Rudy said, sure, and he tells me, why don't you come with me? So that was all the planning that went into that.
So you weren't planned to give a speech? It was not planned?
No plan. I spoke for all of 3 minutes, but that 3 minutes was enough for me to get canceled my classes at Colorado, my tenured position at Chapman University, where I'd been teaching and had been dean for 20 years. Not dean for 20 years, but been teaching for 20 years. The massive amount of pressure by the faculty and
what was your speech for that? I
basically said we know that they had illegality, traditional evidence of fraud, dead people voting, and experts had told me the night before in the Georgia runoff election that they'd seen evidence of machine manipulation, similar to what they saw on November 5th and November 3rd in the presidential election. And so I talked about that, and I said, we need to get to the bottom of this. And any member, any elected official that's not willing to get to the bottom of what happened and tell the American people whether the guy that's about to be certified as the winner actually won the election or not doesn't deserve the office. So Liz Cheney in the crowd over January 6th, when my memo gets published 10 months later, they think they've got the smoking gun for the grand conspiracy to undermine our democracy and steal the election, when in fact what had happened was they had stolen the election. At least that was my firm belief, and it remains my firm belief, that the illegality was designed to alter the impact to benefit Biden. In my California bar trial, they asked me at one point, Now, you don't have any evidence of actual collusion or coordination between election officials and the Democrat Party, do you? And I said, well, let me give one example. I mean, there was lots of evidence. Most of the money, the nearly $500 million that Mark Zuckerberg put in, most of that went to heavily Democrat areas for basically get out the vote efforts for the Democrats. But the example I used in the Barr trial was the night before the election, the Assistant Secretary of State of Pennsylvania sent an email around to all the county clerks basically saying the law that prohibits us from giving you information about disqualified mail-in ballots, we're not going to follow. We're going to give you that information so that the voters can cure their ballots.
Oh, my goodness. Right. So, John, were you the only person in the country or the world who thought about the possibility that the Vice President Pence could defer or could wait or could make a decision about those electors?
Well, there were lots of people that were exploring the very same ideas, both from left and right.
Oh, really? Even on the left?
Even on the left. So when it looked like, for example, that Trump might win Pennsylvania, they were exploring this idea of whether you go back to the 2000 election, the Al Gore team had explored the idea, had the Supreme Court not basically put an end to the thing, they were going to have their own electors meet and cast votes in Florida. On the electors thing, so there were lots. There was an article in Atlantic magazine, I believe, in September of 2020, hand-wringing about the possibility that since Vice President Pence was in charge of the President of the Senate, that maybe he would resolve the disputes, and they were worried about that. And then there were other memos from people working with Trump's legal team outlining what the authority of the vice president was. So my memo that became the cause célèbre, Liz Cheney thought she'd found the smoking gun because Bob Woodward published it 10 months later. It was a summary of the conversations that had been going on for months. They laid out the scenarios that people, both publicly and privately, were already talking about.
And it's clear in either the Constitution or other documents that the president of the Senate does have that power.
It's not clear.
Oh.
It's ambiguous. And the ambiguity, the one thing that I believe is clear is that the House and Senate have no authority. They're just to be present. The vice president has the authority, and this is very clear, to open, it says open all the certificates, and then they shall be counted. Well, because it shifts to the passive voice, they shall be counted, it's unclear who does the counting. And scholars have been debating this for 2 centuries. Since the House and Senate are only to be present, it seems pretty clear to me that they're not to do the counting. And when the unambiguous language, the vice president opens all the certificates, if there are multiple certificates from a single state, you obviously can't count both.
Yes.
So that implies there's some judgment that has to be made on which to count.
Yes.
And I think since the only person that has an active role is the vice president,
right,
it has to be him.
Right.
Right. Other scholars have disagreed. I mean, and we have no resolution of that issue. I think the stronger argument is that it's the vice president.
But it's never happened in American history.
Never happened. Yeah. Back in 1876, the Republicans were all saying it's the vice president that decides this, and then they created a commission, but it's an open question, and people have been debating it, both scholarly and legislators in Congress and in the state legislatures and vice presidents been debating it our whole history.
Well, maybe it should be decided before there's a conflict.
You would think.
Right.
You would think. This is what they said in 1856. We really should resolve this one way or the other so that when it does matter,
right, we'll
the
know
rule.
what to do.
That's right.
Now, John, many Americans believe that there were significant voting irregularities in certain borderline states, and you made legal arguments that those electors should not be recognized until those irregularities were investigated and resolved. It sounds logical to me. So why didn't Vice President Pence, acting as the president of the Senate, take your advice and not do the counting, but say we're going to delay it for a certain amount of time to resolve these issues legally? Why didn't he take the advice?
Well, I think he was reading too much in the New York Times and the Washington Post.
I see. Yeah.
And they were saying, well, we've had these opportunities to challenge this. 65 different courts have ruled against President Trump, so it's already been decided.
I
right.
see.
Now, those 65 cases,
We're not
almost
about this.
none of them looked at any of the merits.
Right.
They were dismissing them on technicalities. There was a case brought before the election against a guidance issued by the Secretary of State in either Wisconsin or Michigan, and it was illegal. It violated the rules of the game that the legislature had set out. And the court said, well, it's just a guidance, and so they actually follow it. Your case is not ripe, case dismissed. And then when the guidance was followed and the illegality occurred on Election Day, they brought the case again, and the court said, you can't wait till your guy loses to bring this challenge. You should have brought it months ago. This was the kind of utter nonsense with the courts punting on looking at the merits of the illegality claims. So that's why we said, okay, they're not going to look at it, then Pence needs to send it back to the legislators. Let them look at it. And it never got looked at. And why Pence did that? I think he became convinced that the founders would not have put such power in a single person. Except when you look at the founders, what is our executive? Except the entirety of the executive power is vested in a single person. Why did they do that? Because they wanted accountability. Why did they put, in my view, this power in the president of the Senate, the single person? They wanted accountability. And how do we ensure accountability? Because whatever he does has to be done in the presence of the House and Senate. It's got to be done in public. And honorable men would not do something dishonorable in public. That was the check that they thought on that power. Vice President Pence just didn't understand the basic principle of the Constitution there, in my view.
So you had that meeting at the White House. And, of course, we all know that Pence decided to count the votes as they were submitted and declared Joe Biden as the president. So what was the first serious shot fired at you for your legal efforts to delay that election?
Well, on the personal front, the demand that I retire early from Chapman University, where I was a tenured professor, the cancellation of my
and that happened within what?
Within a week.
Within a week?
Within a week or 10 days.
And a demand without saying, John, we have a problem with you. Can you come and discuss?
Yeah, no, it was the faculty want you gone. I don't have any basis for gone, but do you really want to spend the next 5 years of your career until retirement dealing with these jerks? Why don't you just retire early? And
Chapman is not a left-wing organization.
Well, it is much more left-wing than people realize. It's one of the dirty little secrets. The undergraduate faculty is as nutty left-wing as most undergraduate faculties. But because it's in Orange County and because some of the more prominent people like me, like Hugh Hewitt, like Vernon Smith, are well-known conservatives, people think it's a conservative school. But before you run out of fingers on your two hands, you run out of conservatives on that faculty.
I see. Yeah. So they demanded you resign.
Yeah, they demanded I retire early. Although the public announcement indicated there was a settlement, and I just leave it for people to figure out whether I had enough leverage to make it a good settlement or not. I was tenured professor, and I'd been the dean. But I will say this, though. Those two things were by private institutions. The governmental attacks on me don't really begin until the following October.
Right.
When somebody leaked a copy of my memo, and Bob Woodward got it and published it, and then Liz Cheney. By then, the January 6th Select Committee is in full swing. And let's be clear, it was Liz Cheney's committee. It was not a bipartisan committee. She was the most virulently anti-Trump Republican. She was appointed by Pelosi, not by the Republican leader, to be on that committee. There was no ranking minority member of that committee, which the Congress has now determined made the committee illegal, made the issuance of the subpoenas illegal because it violated all the House rules on committees and what have you. But I then get a subpoena in November of 2021 from the J6 committee. And what's interesting there is they're demanding basically all of my attorney-client privilege communications. They don't care about me. They want to get Trump. And they think I've got communications with Trump. Now, Trump doesn't communicate with people like me in writing. It's
Right.
all over the
Of course
phone,
not.
so I had nothing. But I had 65 other clients. I had state legislators. I had other things, and they wanted all of that too. And if I assert attorney-client privilege, they had done an extraordinary thing in that committee. They had determined that they could resolve claims of privilege on their own.
Oh, I see.
So if I assert privilege and then they meet for 5 minutes and they take a vote and they say, we reject your privilege claim, now here's the conundrum I'm in. If I answer the question, I'm violating my ethical obligations to my clients and I get disbarred in California.
Yes.
If I don't answer the question, when they've determined on their own that I need to, instead of going to court and have a court resolve whether the privilege claim is valid or not, this was an extraordinary assertion of power by the J6 committee. If I don't answer the question they then hold me in contempt of Congress. They refer it to the Department of Justice like they did with Peter Navarro and Steve Bannon, and I get criminally prosecuted for criminal contempt of Congress. That's a disbarable offense as well. So the only privilege that they can't apply that to is a Fifth Amendment assertion. So in order to protect my client's confidences, I was legally obligated to protect it at all peril to myself. So I asserted the Fifth Amendment. Repeated. I had no choice.
So you showed up, and in every question they asked, you said, I regretfully say that I can't respond based on it might cause me harm or something.
No, I just say I'm not going to be a witness against myself. I use the exact language of the Fifth Amendment.
Good.
And the lawyer representing Liz Cheney kept saying, so that would incriminate you? I said, that's not the language of the Fifth Amendment. And his name was John Wood, and he was a former Thomas clerk as well. And I said, and John, you should know that because you were clerk at the Supreme Court too. Well, it's right there in the Fifth Amendment. I said, why don't you read it right now while we're on the record here? It's not there. It's I have a right not to be a witness against myself.
And that's it.
That's it.
On TV, when you see it, the defendant is saying, I refuse to answer on the grounds that my answer might tend to incriminate myself.
It's just all it says in the Fifth Amendment. I have a right not to be a witness against myself.
I see. And
I kept quoting the Fifth Amendment. And he kept saying, so you're saying that answering that question would incriminate you? I said, I'm not saying that at all. I just have a right not to be a witness against myself.
Perfect. Perfect.
Yeah.
Perfect.
And by the way, one of the reasons, and the Supreme Court has been very clear about this, the Fifth Amendment is there not simply to protect the guilty, that the government then has to prove the case without your help, but it's to protect the innocent. And the Supreme Court has made clear because some stuff can be distorted in order to make it look like a case of criminal conduct, when in fact that's not true. But if you're required to assist that, it's going to entrap people that are innocent.
Understood.
And the Fifth Amendment is there to protect the innocent.
But you showed up when you got the subpoena.
Right.
Now, Steve Bannon didn't, and I never understood why he wouldn't. You just show up and you plead the Fifth, as you did.
Yeah. I don't know why he and Peter Navarro didn't show up.
They went to jail because of that,
They went to jail because of that. Now, nobody refusing to show up in response to a congressional subpoena had ever been charged with criminal contempt, as I understand it.
Oh.
But what they didn't understand was that this Justice Department under Merrick Garland and under Joe Biden was bound and determined to go after them and get their scalps. And it was very likely that they were going to make precedent with these two. And they did. And it was extraordinary. I mean, Peter Navarro, who lived next door to the FBI, could have been asked to come in and turn himself in any time. They waited until he's going off to give a speech, arrested him at the airport in a very public way, put him in handcuffs and leg irons.
Oh,
and then held him in the cell in the D.C. jail where John Hinckley had been held, an assassination attempt guy. This was an outrage. But it was part of the narrative that these people tried to undermine our democracy and we need to throw the book at them. It was a fault. The book I'm working on is called The Big Lie, but it's in quotes. They kept saying that Trump was engaged in the big lie, but the actual big lie was that what Trump was saying and trying to highlight illegality in the election was a big lie. So
that was the lie.
No,
So it's possible that Bannon didn't know that they were going to put him in jail for not showing up.
Maybe, or standing on. Look, he was asserting executive privilege. Peter Navarro had even a stronger claim for executive privilege. The president ordered both of them stand on executive privilege claims. Mm-hmm. Joe Biden, for the first time in our history, rejected a claim of executive privilege that had been asserted by his predecessor. That never happened, because the reason it had never happened is because even a subsequent president understands it's the office you're protecting, not the particular individual. He didn't care. The virulently anti-Trump mentality of that whole crew was so strong that they throw away the office's prerogatives in order to get Trump.
Mm-hmm. Now, a little later, on August of 2023, the Department of Justice indicted former President Trump for election interference. You were listed as a co-conspirator in that case, so why weren't you indicted as well?
Yeah, don't tempt anybody with that question.
Is it too late?
So I think Jack Smith had decided he wanted a clean, fast track to getting that case heard before the 2024 election. And when you add multiple defendants, you add exponentially increased complication. Just look at what's happening down in Georgia, where Fani Willis brings the criminal indictment against Trump and 17 others, including me. It's just been a nightmare of chaos with motions flying back and forth. And, you go into the courtroom and you got, 30 different lawyers. There's no room for anybody else. And so Jack Smith was trying to streamline it. He wanted this case resolved in time for the 2024 election. Because the whole point of these cases was to affect the outcome of the 2024 election, which, by the way, in my view, is a federal felony. And it'd be very interesting to see what the current Department of Justice is going to do with those federal felonies.
So I get that now. Now, the Justice Department did investigate you, but never charge you with a crime. But you are still fighting felony charges in 2 states, Georgia and Arizona. Now, if the DOJ didn't indict you, what could the states possibly have against you?
Well, it's in Georgia, they've claimed that we're part of a criminal enterprise. They're using the racketeering statute that was designed to go after the mob. And criminal enterprise.
But you didn't do it in Georgia.
I didn't. I testified before the legislature. No, let me get this straight. I responded to a request from a state legislator in Georgia to testify at his hearing about the authority that the legislature has under the Constitution. And I did that. And one of the charges against me by Fani Willis, the ethically challenged DA in Fulton County, Georgia, in Atlanta, is that by testifying at their request, I was soliciting them to violate their oath of office. Now, that charge has been dismissed, but Fani Willis is still appealing it, even though she has been disqualified. So we've challenged her ability to continue to prosecute this case by filing appeals of these substantive decisions that are unrelated to her disqualification appeal. And that's pending before the Georgia Supreme Court right now.
And what's the story in Arizona?
So Arizona, where I had, again, I wasn't involved in any of the Arizona litigation. I didn't testify before the Arizona legislature. I had no involvement with any of the electors in Arizona. But in response to a request from a state legislator, I had a phone call with the Speaker of the Assembly or the Senate that they had authority to call themselves into session to assess the impact of illegality. That was it. But that was enough, and the aggressive Democrat Attorney General there to add me to the criminal indictment. And so I'm charged with conspiracy to commit forgery and to impersonate, because the electors met and they're saying when the electors signed their own names when they really weren't the certified electors, that was forgery. It is bizarre. But those conspiracy charges were brought last April in Arizona. So I've now got a legal team in Arizona. I got a legal team in D.C. I got a legal team in Georgia. Got a legal team out in California with the bar, the longest and most expensive bar disciplinary proceeding in history, we think, in California. I got a legal, the author of the book, 3 Felonies a Day, Harvey Silverglate, is one of my legal team. He's based in New York and Boston. So I'm becoming a full employer of lawyers, I guess. I don't know, but it's nonsense what's going on.
No, it's just punishment.
It's punishment.
Right.
Even if I win all these things, the process has been punishment of its own. We've already racked up probably $1.6 million in legal fees. I've defended against 18 different actions. One of them, I was the lead defendant in a case brought by a guy in North Carolina. It was me, and it was Sean Hannity, and it was Fox News, and it was Rupert Murdoch, and Ivanka Trump, and Mark Zuckerberg, who was on the other side of this thing. And one of the allegations was these are all billionaire oligarchs trying to undermine our democracy. So,
And where is that?
yeah, it was in North Carolina. It was brought in D.C., but it was by somebody in North Carolina that filed suit. Now, that was dismissed. It was frivolous, but it cost 20 or 30 grand in legal fees
just to
respond to that. But my wife thought it was funny that I was accused of being a billionaire oligarch. So those of you out there helping with my legal defense fund, I'm not a billionaire oligarch.
So what are the next steps in the process to try to disbar you in California?
So after a 10-week-long trial.
You had that?
Yeah, we had that in
10 weeks.
10 weeks long, 34 days of trial, full trial teams. You can imagine. Racked up over $750,000 in legal fees on that alone. And then the judge, who continued to donate to Democrat candidates, and some of her donations were sent to organizations going after Trump with the Lawfare. She's actually donating to the entities bringing these complaints. The judge, while this is all going on. So we challenged that on appeal, a violation of my First Amendment rights, a violation of my due process rights, and then we looked at the claims that I had made false statements were based on hearsay by, Secretary of State of Michigan put a press release out that said their election was perfectly legal, and I said it wasn't, so therefore I must be lying. I mean, it really was Orwellian that the government has spoken, and if you dare to question the government, then you must be lying, and if you're a lawyer and lying, therefore we can disbar you. And it really is an infringement on First Amendment rights. Look, nobody has a monopoly on truth. The way we get to truth is the adversarial process. And if I'm not allowed to question,
especially for your client.
For my client, if I'm not allowed to question that, then things that are blatantly false all of a sudden become true because nobody's willing to stand up and say otherwise.
So you are licensed, you continue to be licensed to practice in front of the Supreme Court. So one would think that if you have that license, then you should be allowed to practice in California or anywhere. But that's not right, huh?
Well, that's not right. The California Bar Court judge has no authority to disbar me or suspend my license. But upon the mere recommendation of disbarment, my license is put on inactive status in California. And several other courts, the D.C. court, where I'm also licensed, followed suit and said, well, if California thinks you're inactive, then we do too. And a couple of federal courts where I had cases pending on behalf of clients without following Supreme Court controlling precedent said they have to conduct an independent assessment. They said, well, if California thinks you're inactive, then you can't practice here either. Even though the Supreme Court of the United States has said, thanks for the information about the recommendation, let us know if they take any action. So in the meantime, the Supreme Court hasn't put me on inactive there, and I'm still practicing. So I can practice at the Supreme Court of the United States, but not the Superior Court in California. It's insane. It's insane.
So as of today, your ability to earn a living as a lawyer is gone.
In large part, although most of my practice is in the Supreme Court.
Oh, okay.
So I'm still able to do that.
Good.
But quite frankly, my ability to earn a living as a lawyer, quite apart from the license issue, is I'm spending full time trying to stay out of prison in Atlanta or Maricopa County, Arizona, because of these criminal defense things. I'm one of the leading experts in the country on these constitutional issues, First Amendment issues, separation of powers, electoral college. So I have a very active role working with my legal teams in those jurisdictions to make sure the right arguments are getting presented. Now, I'm also very well aware of the old adage, a lawyer who represents himself as a fool for a client. So I make recommendations to my teams based on my expertise, and they bring to bear their expertise, which is criminal defense bar.
Now, what do you think of President Trump's appointment of Pam Bondi to head the Department of Justice?
I've been very impressed with all of President Trump's appointments, but I'm particularly pleased with Pam Bondi, and even more importantly, because I think for Pam to do her job in criminally prosecuting people that were, in my view, engaged in a nationwide conspiracy against President Trump and me and others, that what she needs is the investigative work from the FBI.
Yes.
And so even more important from my perspective is the Kash Patel.
Sure.
Yeah.
Sure. But President Biden gave immunity or he issued pardons to them. I don't know how you issue pardon to somebody who hasn't been charged with a crime, but I guess you could do that kind of thing.
Well, we had a couple of examples. Gerald Ford gave an immunity, a pardon to Richard Nixon before he'd been charged with any crime, to trying to bring peace. Both Ford and Carter gave pardons to Vietnam War draft dodgers, even though they hadn't been charged with anything.
But just because they did it it's a precedent, doesn't mean it was accurate,
that's right? The Supreme Court's been pretty clear, though. The couple of cases they've had dealing with pardon is it's the president's prerogative. What they can't do is pardon you for something you haven't done yet.
Yeah, I see.
But the pardon can be done for things you've already done, even though you've not been charged yet. But you got to do it by signing the pardon.
That's in the news today, right?
Yeah, you got to do it by signing the pardon. You can't have some staffer use your auto pen and sign pardons without your knowledge. And so President Trump has just announced that he views all of those pardons as null and void because they weren't signed by President Biden, and they weren't even authorized by President Biden.
Well, I don't know how he can say that.
Yeah, well, because the investigation of President Biden's retaining of classified documents when he was vice president, where he didn't even have the authority to declassify them.
Correct.
The reason that prosecution wasn't brought is because he was too mentally incompetent.
That's what the prosecution would
That's
say.
Right. If he's too mentally incompetent to be able to deal with the classified documents, then he's too mentally incompetent to knowingly authorize the signing with his auto pen.
Well, that's a very good point.
Yeah. So you bring all those things, or Mike Johnson interviewing, you just signed this executive action dealing with LNG contracts in Europe. He said, no, I didn't do that. Well, he had done that. He had no idea. So you got all this circumstantial evidence, but there are two things. Even if the pardons are valid, and I think we're going to make some new Supreme Court precedent here before that's done. Can a pardon signed by an auto pen be treated as a valid pardon? That would be Hunter Biden, it'd be Liz Cheney, it'd be Anthony Fauci, it'd be the whole bunch of them. Even if the courts hold that those pardons are valid, very important. What does that mean? That means you can haul Liz Cheney before a grand jury. She can no longer assert the Fifth Amendment and refuse to respond because she has no risk of being a witness against herself because they can't bring a prosecution against her. She has to then spill the beans. If she lies about the beans, she can be criminally prosecuted for perjury because that's a crime that occurred after the pardon.
Understood.
And if she refuses to answer, that's a criminal contempt. And you ask Steve Bannon and Peter Navarro what the results of that are. She can be criminally prosecuted for that.
Wonderful.
Yeah.
So do you think the Department of Justice is going to pursue these people?
I hope so, because I think what went on for the last 4 years never should have happened. Yep. And unless you hold the people that did it accountable in a very serious way, I'm not talking about a slap on the wrist with a little fine.
Serious way. Yeah.
Serious way, serious prison time, then they'll do it again. And I think whether Pam Bondi would do it on her own, I guarantee you Kash Patel doing the investigation, wrapping that case file up with a bow and nipping at her heels to make sure that it's done. I think we're going to see some action there.
So do you think he'll be able to reform the FBI?
I hope so. One doesn't know how deep the rot goes down into the rank and file.
Right.
The FBI agents that seized my phone in Santa Fe, New Mexico, I think are decent agents and were following orders and didn't have enough basis
to not follow
to not follow the order. Military, you're not allowed to follow an illegal order, right? But tell me which private first class
is going to assert that.
Right. So I think there's a lot of rank and file that will be back to the old FBI with proper leadership. The evidence I have for that comes not from the FBI, but comes from our border control agencies, ICE and Border Patrol. And the enthusiasm with which they have started doing their jobs again, when they've been unleashed to do the jobs that they signed up to do, gives me optimism that the same thing will happen in the FBI.
But what's been nagging at me for the past week or two, President Trump said we're going to give the public all the records for the assassination of President Kennedy, the assassination of Robert Kennedy, of Martin Luther King, of the Epstein tapes, the Epstein files. We're not getting them.
We're not getting.
So to me, it means there are people in certain powerful positions, not the leaders of these organizations because they've been gone already, but there are certain people in key positions who are refusing to expose those or to bring forward those files, or they're threatening the people who are asking for the files in various ways. There's malfeasance happening.
Yeah. So I'm gonna put the best spin on it that I can, and then I'll agree with you. So here's the best spin I can put on it. If let's take the Kennedy assassination, if in fact the Soviets were implicated in that, and those files are released, that creates a potential major rift in international politics. Our biggest enemy right now is China, not Russia.
I agree.
And the delicacy of foreign policy questions needs to be taken into account always. If something like that is or same thing with the Epstein files, there may be things like that could trigger a third world war because we're exposing an ally to be an enemy or whatever. And these are delicate questions. I have no idea whether that's the case or not.
Right.
But if it is, it could explain some of the...
I see.
On the campaign trail, before I know what the issues are, it sounds like something we want to do. And then somebody legitimately points out, we do that, we could end up losing our main ally in Saudi Arabia trying to negotiate peace in the Israeli-Gaza war. These are delicate things, and okay, we're going to slow it down a little bit to kind of assess that and then make a judgment. That's possible. I don't know whether that's going on. It's also possible, and much more likely in my view, that in fact the deep state thinks that they're not going to follow Trump's order because they control things, not him.
Right.
And I got to tell you, there's a lot to support. I was on the phone with the President of the United States multiple times in December of 2020 when he got somebody else on the phone and issued a direct order to do something, and the next day I'm reading in the press that they'd done exactly the opposite. We have developed an entrenched, unelected, unaccountable bureaucracy that thinks the president and hence the American people work for them rather than the other way around. So I have... my strong suspicion is, in fact, that's what's going on.
Yeah. Well, the president has the power to hire and fire political appointees, such as cabinet secretaries, U.S. attorneys, ambassadors, and heads of the agencies like the FBI and CIA. But the swamp is very deep. He can only skim the slime from the surface of the swamp. But I don't think he can drain the swamp because he doesn't have the power to fire most federal employees. So what do you, given it's all these senior level people who are against America, really against our way of life, how do you see the future?
Well, this is one of the brilliance of the strategy that Trump and his inner circle team worked for 4 years putting in place. And among the initial executive orders signed on January 20th was a direct challenge to the view that I can't fire people in the executive branch, that the career civil services protections that have been implemented by statute prevent me from removing people that are derelict in their duties, that are running counter to the agenda that I was elected to further. And he's going to confront a prior Supreme Court decision that allowed that to happen, that in my view and a lot of scholars' views, is about a 100-year-old case, was wrongly decided. And I think they're challenging that decision.
Wonderful.
Because the Constitution's pretty clear. The head of the USAID doesn't exercise executive power. The executive power is vested in the president, all of it. And anybody below that only has power derivative from him. And if Congress says you can't fire that person at CFPB,
then what does it mean to be the executive?
That's right. Then he doesn't have control over the executive branch. He can't fulfill his constitutional duty to take care that the laws be faithfully executed. And he's challenging, I believe, that old doctrine that says you can't fire these executive employees. And I think he's going to win that fight in the Supreme Court. He'll lose in all the Obama judges and Biden judges and injunctions and all of that in the meantime. But when it gets to the Supreme Court, I think we're going to win that fight 5-4 or 6-3.
Fantastic. Yeah, that's what's necessary.
And it will hold the executive branch, rank and file, and the senior executive service accountable to we the people, because they'll be accountable to the president that we've elected.
John, thank you so much for spending time with me today to share the details about the advice that you gave to President Trump and the horrible resulting fallout for simply doing what you were trained to do for your clients. I pray that the ongoing cases that you're involved in will all be settled in your favor.
Thank you.
If you want to learn more about John's story, you can watch a very recent documentary entitled The Eastman Dilemma, Lawfare or Justice. The film had its debut in January at an event held by President Trump at Mar-a-Lago. But you don't have to go to Palm Beach to see it. You can watch it for free at the following website. It's all one word, MadisonMediaFund.org. John Eastman, like every good attorney, believes in and lives by the founding principle of his profession, which is to give each client the best legal advice possible. And that's exactly what he did for his client, President Donald J. Trump, back in December of 2020 and in January of 2021. But because of that, because he used his expertise to advise President Trump on ways to legally challenge the outcome of the 2020 election, he has been prosecuted, more like persecuted, by the left's weaponized legal system that has been relentless in its continuing efforts to destroy him. I'm helping to pay for John's defense against those assaults. You can help too, if you want, by donating online via GiveSendGo. And here is the URL. It's givesendgo.com/Eastman. I'll say that again. It's all one word, givesendgo.com/Eastman. Alternatively, you can donate by check made out to the John Eastman Legal Defense Fund and mail it to the address shown below on your screen. Thank you for watching, and if you enjoyed this episode of Life Lessons with Dr. Bob, please subscribe and you'll be automatically notified of future podcasts in this series.
Thanks so much for listening to another episode of Life Lessons with Dr. Bob. If you enjoyed these interviews with some of today's most influential thought leaders, please follow and rate the show on your favorite podcast platform. And don't forget, you can also watch each episode on YouTube as well. We'll see you next time.